Mr. President.
Senator from Utah.
Mr. President, today I rise in favor of immigration reform. The current immigration system is a travesty. It's inefficient, it's uncompassionate, and it's dangerous. It doesn't serve America's economic or social interests, and it undermines respect for the rule of law, while simultaneously undermining respect for our democratic institutions. Comprehensive reform is both badly needed and long overdue. The comprehensive immigration reform I envision includes real border security, visa modernization, employment verification, robust programs for both high and low-skilled workers, and a compassionate approach to addressing the needs of those currently in the country illegally. But I believe that each of these vital components must be addressed incrementally and sequentially in order to ensure meaningful results. Now, I understand our reluctance to admit it, but Congress is simply very, very bad at overhauling and creating massive bureaucratic systems all at once. Every new law, no matter how big, carries with it some unintended consequences. And the bigger the law, the more accidental problems that we tend to create. History teaches us that trying to fix lots of problems all at once is the surest way to avoid fixing any of them very well. Obamacare is and will continue to make our health care system worse, not better. It promised to lower health insurance premiums, yet they're exploding all across the country. The Dodd-Frank financial reform measure was supposed to end too big to fail and prevent another financial meltdown. And yet, Fannie Mae and Freddie Mac are still on the taxpayers' books, and today, the very biggest banks on Wall Street are bigger than ever. Did the American people have any idea that the Patriot Act would empower the National Security Agency to spy on all Americans through their cell phones and their computers? What makes any of us, least of all any conservative, believe this immigration bill is going to work out any better? The lesson we should be taking from our recent mistakes is not that we need to pass better, huge, sweeping new laws, but that we should instead undertake major necessary reforms incrementally, one step at a time and in the proper sequence. We need to face the fact that 1,000-page bureaucratic overhauls simply do not achieve their desired goals, and they create far more problems than they tend to solve. We can achieve comprehensive immigration reform without having to pass another 1,000-page bill full of loopholes, carve-outs, and unintended consequences. Therefore, from my perspective, there's no one amendment that can fix this bill. Indeed, there's no series of tinkering changes that will turn this mess of a bill into the reform the country needs and that Americans deserve. The only way to guarantee successful reform of the entire system is through a series of incremental reforms that ensure the foundational pieces, like the border security pieces and an effective entry-exit system, are done first and done correctly. Such a common-sense process will allow Congress and, more importantly, will allow the American people to monitor policy changes as they're implemented with each step. That way, we can isolate and fix unintended consequences before they grow out of control and before we move on to the next phase. A step-by-step approach would also allow Congress to move quickly on those measures on which Republicans and Democrats both tend to agree. We ought not hold common sense and essential measures hostage to unavoidably contentious ones, and that's what this bill does. Both sides largely agree on many essential elements. These measures are relatively uncontroversial and could pass incrementally, with broad bipartisan support in Congress. Indeed, the only reason immigration reform is controversial is that Congress refuses to adopt the incremental approach. That is why true immigration reform must be pursued step by step, with individual reform measures implemented and verified in the proper sequence. Happily for immigration reformers like me, this appears to be the approach being pursued by the House of Representatives. It's the only one that makes sense. First of all, let's secure the border. Let's set up a workable entry-exit system, and create a reliable employment verification system that protects immigrants, protects citizens, and protects businesses from bureaucratic mistakes. Then let's fix our legal immigration system to make sure we're letting in the immigrants our economy needs in numbers that make sense for our country. There's no good reason why we must, or even why we should, try to do these things all at once, all in one bill, all in the same legislative package. Once these and other tasks, which are plenty big enough themselves, in and of themselves, are completed to the American people's satisfaction, then we can address the needs of current undocumented workers with justice, compassion, and sensitivity. Since the beginning of this year, more than 40 immigration-related bills have been introduced in the House and the Senate. By a rough count, I could support more than half of them. 8 of them have Republican and Democratic co-sponsors. We should not risk progress on these and other bipartisan reforms simply because we're unable to iron out each and every one of the more contentious issues. This is not the bill to fix our immigration system. Now, I want to pass immigration reform. I want to debate immigration reform. And that is exactly why we should not proceed to the Gang of 8 bill. We're being presented with a choice between the Gang of 8 bill or nothing. Common sense, recent history, and the ongoing legislative process of the House of Representatives confirm that that is a false choice. There is another way. It's a more sensible and a more successful way. We can do better than another 1,000-page mistake. Haven't we learned our lesson in this regard? Isn't it time that we tried? Rather than fix our current immigration problems, the Gang of 8 bill will make many of them worse. It's not immigration reform. It's big government dysfunction. All advocates of true immigration reform, on the left and on the right, should oppose it. Thank you, Mr. President. I yield the floor and note the absence of a quorum.
The clerk will call the roll.
Mr. Alexander. Ms. Ayotte.
Earliest hours of the Senate day today as things are just getting underway. Lawmakers debating bipartisan immigration legislation throughout the day. The proposal would create a conditional path to citizenship for the nearly 11 million undocumented immigrants living in the U.S.
And I would ask consent, Mr. President, that I be allowed to engage in a colloquy with Senator Lee.
Without objection, so ordered.
Mr. President, I thank the Senator for his comments and his insight and contribution to the debate, his clear mind and thinking that really caused us to analyze how to handle things. And the problem we have today at a most fundamental level is in 1987, as Senator Grassley has been so passionate and so clear about, he voted for the 87 amnesty. And there was amnesty occurred immediately, and there was a promise of enforcement in the future. And so Senator Grassley's view and the view of the American people, by a 4-to-1 margin, a recent poll just said, let's have the enforcement first, then we talk about amnesty. All right? So Senator Lee, you offered an amendment that kind of dealt with this process. Under the legislation that we have here, the question of enforcement is almost entirely given to the Secretary of Homeland Security. He's basically said enforcement's good now. We don't need any more enforcement. and that she would basically certify or establish whether or not we have an effective border and enforcement system. And if not, and she just had to issue a report, and then you could turn it over to a commission that had no power, and they could review it. But that really absolves Congress of responsibility. From that background, you offered a very interesting amendment that I think placed responsibility for enforcement where it should be. Would you explain your thinking?
I certainly would. I'd be happy to. In the Judiciary Committee, on which the senator from Alabama and I both sit, during the markup session on this bill, we were able to propose a number of amendments. One of the amendments that I proposed, Lee Amendment number 4, addressed this very problem, the problem inherent in the fact that much of what this bill accomplishes is to outsource and delegate many of the delicate tasks, many of the delicate decisions that have to be made along the way in the implementation of this bill. They outsource to the Secretary of Homeland Security the task of coming up with a border security plan and a border fencing plan. And once those plans are in place and once the Secretary makes the necessary findings under the bill, which she has basically complete discretion to do, then the RPI status begins, the pathway to citizenship commences, and citizenship from that moment forward, from those who meet the basic eligibility standards, becomes more or less a virtual certainty, become at least very, very likely. And so my concern was that Congress would have no subsequent input in this decision. Each of us has been elected from this body, and each of our colleagues in the House of Representatives has been elected to that body to make decisions, to make law, and not simply to make outside lawmakers who will make incremental pieces of law on the outside. Each of us will stand accountable at regular 6-year intervals in this body and at 2-year incremental periods in the other body to the voters who placed us here. And each of us should have the opportunity to decide whether and to what extent the border has adequately been secured, whether and to what extent we have enough fencing along the border in order for us to begin this legalization process and the pathway to citizenship. So Lee Amendment number 4 to this bill would have said simply that the RPI status, this pathway, would not have commenced until such time as Congress had the chance to vote on whether or not we had made sufficient progress towards securing the border and fencing the border before the period of legalization started. It's a very simple question, and it's the question that lies at the heart of the concerns surrounding this very bill. It's the question that lies at the heart of the lingering concerns regarding what we did back in 1986. Now, I was only 14 years old at the time that debate commenced, and so it was not the forefront of my mind, although perhaps it should have been. But the lingering concerns surrounding what happened in 1986 relate to the fact that Congress said, in effect, we're going to go ahead and legalize the several million people who are here illegally right now, and then once and for all, we're going to secure the border. We're going to stop the flow of illegal immigration once and for all. Well, it didn't happen because they sort of put it off, and they said at some unknown point in the future the border will in fact be secure. This would have solved that problem. It at least would have kept members of Congress on the hook for finding that the border was adequately secure by requiring a subsequent vote before the pathway to legalization commenced. Now, to my surprise, to my dismay, and to my frustration, it was rejected, and it was rejected along the lines of a particularly odd argument. The argument went something like this, from those who professed their undying loyalty to the Gang of Eight bill as it was originally drafted. The argument said, in essence, we cannot adopt Lee Amendment number 4 because we can't trust Congress to do the right thing. We can't trust Congress to do what we want Congress to do. In particular, the argument was made, we can't be certain that the House of Representatives, currently under control of the Republican Party, will in fact vote to commence the legalization process. Well, if that's the case, aren't we really saying we can't trust the democratic process? If that's the case, aren't we really saying that the American people aren't yet comfortable with that? So I'd ask my colleague from Alabama, why should we not trust the elected representatives of the American people to make critical decisions like these? And why should we instead outsource them to someone who, having been appointed by the President and confirmed by the Senate, doesn't respond, at least not directly, to the people at regular intervals in elections?
I would just say this is a very important amendment, and I think it reveals a lot, as you just have indicated. You know, when we vote on an amnesty bill, and if that were to pass, the senators voting for it are basically promising the American people, giving assurances to the American people that they will end the illegality in the future. Because, as I noted, the polls are 4-1 that you should have the enforcement before you give amnesty, and the reason is a lack of confidence. So, Senator Lee, I think if your bill had been passed, it would place some burden on us, a moral obligation to stand before the world at a point in time in the future and declare whether or not we've accomplished what we promised the American people we would do. Is that the way, part of your thinking?
Yes. That is exactly why I introduced Lee Amendment number 4 in the committee, and why I think it should have been passed, is because the whole reason why we entrust the legislative power only to people who are elected at regular intervals and stand accountable to their electors at regular intervals is because of the fact that it is perhaps the most dangerous power of government. You know, we can do a lot of damage when we make law. And as a result of that potential for damage, that potential for harm that we can inflict on the people, we have to stand accountable in incremental time periods of either 6 years or 2 years to make sure that we don't abuse that power. And that's why it's so harmful when we take that very dangerous, potentially destructive power and we outsource it. Now, to some extent, in different ways, this has been going on for many decades. It started more or less during the New Deal era, when Congress discovered that as the federal government was dramatically expanding, Congress physically couldn't come up with the immense and steadily building task of legislating, of doing all the lawmaking, all the rulemaking that it needed to do. And so it started passing broader pieces of legislation, setting out very broad objectives, and then outsourcing to some outside body, sometimes a cabinet-level official, other times a so-called independent commission, to do the real lawmaking. Now, Congress during this time period discovered an interesting and important tool. During this time period, it discovered that, you know, sometimes we as members of Congress are not going to like the way that the outside body or the outside official within the executive branch might exercise this delegated lawmaking authority. So we'll reserve to ourselves, we'll reserve to Congress an out, a legislative veto, as it became known. In some instances, this legislative veto allowed either House of Congress, either the House or the Senate, to undo a rulemaking or an important decision made by an executive branch official or entity. In other cases, it required both houses to act in unison. But these legislative veto provisions did not require subsequent presentment to the President, who could then sign or veto that legislative veto. This went on for several decades. It went on until the mid-1980s when the Supreme Court intervened in a case called INS v. Chadha, occurring interestingly enough in the immigration context, occurring interestingly enough in the specific context of a decision by the Attorney General to exercise delegated authority from Congress to issue a discretionary waiver of deportability to an otherwise removable alien. The Supreme Court said that this legislative veto was itself unconstitutional because it amounted, in essence, to a subsequent enactment by Congress that was not subject to the presentment requirement of Article 1, Section 7 of the Constitution. Thus, the Supreme Court concluded in INS v. Chadha the legislative veto provision, as it had been used for many decades, was itself unconstitutional. It was invalid. It was stricken. Now, some might have predicted that as of the moment of the issuance of this decision in INS v. Chadha, that Congress would say, that's it, we're not going to delegate this much authority anymore, because we can't trust these outside officials, these outside entities within the executive branch of government to do the lawmaking. That's our job. But that's not what happened. Shockingly, in the eyes of some, Congress continued to delegate its lawmaking authority left and right. If anything, it has accelerated its delegation of lawmaking authority, in part because members of Congress like, first and foremost, to wash their hands of things. In the grand tradition of Pontius Pilate, we're sometimes inclined to wash our hands of things and push important decisions off to someone else to make them, someone else who can take accountability for those decisions. Makes it easier for us. And in some ways, that's what's happening here. In some ways, that's what we're doing here by pushing off to the Secretary of Homeland Security the decision to make a decision that we ourselves ought to be making. That decision ought to rest here so that we ourselves can be held accountable. Well, we are not sovereigns unto ourselves. We certainly ought not be making sovereigns out of someone else who need not stand accountable to the people.
Senator Lee, thank you. I think that's a very wise insight. And on the question of immigration, Congress has been irresponsible. The American people have pleaded with us to end the illegality and create a lawful system that serves the national interest, a system that we can be proud of, and for 30 years Congress just fails. And your amendment requiring that vote by Congress to assure that we've done what we promised reminds me of what happened in 2007. Another bill was omnibus comprehensive immigration. We didn't have confidence about the future. And in the course of that debate, I think maybe shortly after the bill failed, we'd had an amendment to build a certain amount of fencing on the border. And I offered it. And it passed overwhelmingly. Republicans and Democrats, virtually everybody voted to build more fencing at the border. It was 700 miles out of about, 1,700 miles border. And everybody was for it. But that's just the first vote, as our colleagues know. The second vote is, will anybody appropriate any money to build the fence? So not long afterwards, up comes an appropriations bill for Homeland Security, and it had no money for the fence in it. So our colleagues going back home, I voted to build a fence. But here we have a bill on the floor that doesn't have any money to build a fence. The fence wasn't going to get built. So I raised Cain about it, and fussed and sort of mocked the Congress for one moment saying you're going to do something and not stepping up to the plate a little later, and they put money in for the fence. But you know what happened? The double-layered fencing that was required, 700 miles of it, only 30 were built. They came up with this idea of a virtual fence. Airplanes and computers and radars, I guess. It was a total failure. We spent $1 billion. It was abandoned. There's only about 30 miles of double fencing, a number, 100 or so miles of automobile barriers, and it was never built. So if we'd had to vote again to affirm what we did in a year, I think that would make it more likely, from my experience here about how this body works, that it would make it more likely that what we promised would get done. Do you agree?
Yeah, I certainly do think that would make a big difference. If we had to vote on it, it would have a couple of effects. First of all, the fact that we would have to vote on it would have an impact on the executive branch of government, whose job it is to implement laws that we pass. So the executive branch of government would know they had a duty that we'd be following up on. not just in some amorphous oversight committee hearing context, but we would be exercising oversight in a very real way, in the sense that we would have to vote on whether or not they had done something adequately within a specified period of time, and there would be consequences, very real consequences, if we were to refuse to exercise that vote. And this vote would go through the normal process. It would be debated, discussed, and acted upon in both houses of Congress, and then submitted to the President for signature or veto, and it would therefore be wholly consistent with the presentment clause of the Constitution. Now, some have suggested that this might be a bad idea because it would perhaps get held up through some procedural mechanism or another. But the way the amendment was written, that would not, in fact, be the effect. This would be a privileged motion through which it could come to the floor. It would go through the Senate on a 51-vote threshold and would therefore be able to move through quite quickly. And so that's why it's important for this kind of mechanism to be in a bill like this.
Well, I just want to thank you, because the danger, the problem that's so very real, as Senator Grassley has so eloquently discussed. It's one thing to grant amnesty today. It's another to see in the future that we follow through on a system that will end illegality in America. And Senator Lee, you're a good lawyer, and you've been involved in a number of these issues. It's very clear that the Immigration Lawyers Association of the country was involved in the drafting of this legislation. And I don't say it was all done just for their personal gain, but did you notice quite a number of alterations in current law that gave more flexibility, more uncertainty, where the law says thus and so, but it can be waived for hardship or family problems or other matters. And as a lawyer, what at first glance would be a open and shut case where your client's in the country illegally, they're due to be deported. Now the client can demand a trial and perhaps overload the system. Everybody claims hardship. Everybody claims some other exception to the rule, and that we could have, is there a danger that our whole enforcement system could be bogged down in litigation we've never had before?
Yes, it certainly could be, and it certainly would be, if at the end of the day you have literally hundreds of instances of secretarial discretion built into the bill. If every one of these important decisions that have to be made along the way or through the process of legal immigration, if any of the critical decisions that have to be made along the way are subject to certain rules, but those rules can be waived by the Secretary at the Secretary's unfettered discretion, it's not much of a law. It becomes something else. It becomes a set of guidelines with ultimate discretionary decision-making vested in the Secretary. And that's something very different than a law. Now, I don't doubt that there were lots of people who had input on this bill, nor do I necessarily blame any one group for being involved. They have every right to give their input into a law. But at the end of the day, we have to ask the question, whose job is it to legislate? It's not their decision to legislate. The accountability to legislate or the accountability for flaws in this bill, therefore, must not rest with any outside group, with any group of lawyers or activists of any stripe or at any end of the political spectrum. The accountability for the legislation that moves through this body must rest ultimately with us. And that includes legislation that gives someone else the effective power to legislate, as this one does in literally hundreds of instances. So if at the end of the day, this bill, assuming it's passed out of this body and passed by the House of Representatives and signed into law by the President, if this bill at the end of the day says, for instance, that the Secretary may, at her discretion, waive certain exclusions, that would otherwise prevent somebody from entering onto the pathway to citizenship on grounds that they had re-entered the country after previously being deported. That's a pretty big issue, because at that moment, somebody who has re-entered the country after previously being deported, they've committed a felony. Now, the point has been made many times that it's not necessarily a crime to enter this country illegally. It's considered by most to be a civil violation. But that changes when you've been previously deported. A previously deported illegal alien who re-enters following deportation has committed a felony offense. So if the legislation that we're considering now becomes law, and if at the end of the day, as enacted, it allows for those people to enter into a pathway to citizenship, I think that's cause for concern. It's one of many areas in which we need to be very cautious in granting this much discretion to the Secretary of Homeland Security. Now, it's interesting, Senator Sessions, I got a letter from a woman in my home state of Utah, a woman who's a school teacher in American Fork, Utah. She's an immigrant to this country. She's here on a non-immigrant visa. She sent me a letter saying, I've spent years of my life and thousands of dollars immigrating to this country legally, the right way. I have a job, it's a good job, a job that I love, a job teaching school. But I'm here on a visa, and that visa expires in a few years. And I know that when that visa expires, unless somehow I'm able to get that visa extended, unless I'm able to get another visa, I will be sent home. I will have to leave this country. And it breaks my heart, she wrote, that at the same time that I'm going to have to leave this country, there will be lots of people, in fact, 11 million or more, who are currently here illegally, who have broken the law in coming here, many of whom have been working here illegally, who will not only be allowed to stay, not only be allowed to stay in their current job, but be put on a pathway to citizenship. And she said, this seems like a profound unfairness, that we're rewarding those who have broken the law, we're punishing people who, like me, the school teacher who came here on a non-immigrant visa, have spent years of their lives and thousands of dollars trying to do it the right way. Don't you think that's a cause for concern? Cause for concern that relates to this excessive granting of discretion?
I couldn't agree more. And when you, as I had the honor to do, prosecute violations of federal law for over 14 years, and you feel a deep, abiding sense that fairness has to occur. Because you're putting somebody in jail for a period of time. You're saying you don't get this money. If they made a claim, you can't give them, even though they might benefit, but they just don't qualify. And you do these things day after day, and you have to believe that the system works. And with regard to immigration, it's so deeply important that people who wait in line, who do the thing the right way, feel like that others aren't getting away with it, that aren't beating the system. Then they feel like chumps. They feel like they've been had by the system. And it's such a deep moral responsibility, not just for the federal prosecutors, and the ones I know feel deeply about this. They feel really that sense, because you can't do your job every day and go to bed and sleep if you don't feel like everybody's at a lead. And you do a tough job one day, you don't qualify for disability, you don't qualify for money, you have to go to jail. The guidelines say you go. The next guy comes along and the guidelines don't apply to him. The next guy files a claim and he gets some money and you didn't. I mean, it's so critical for the magnificent legal heritage of our country that the law be followed equally. And anybody that suggests that this amnesty that will occur has no moral consequences do not understand the depth of the question involved. So if we do it, and if we do something very compassionate for people who are here illegally, the American people are correct to say, do not let it happen again. Do not let this happen again. The way the law should work in America, you come legally, okay. You don't come legally, you get deported. That's what the law is. That's what it should be. Anything less than that cannot be defended morally. Can't be defended constitutionally. Can't be defended legally. It can't be defended as a matter of policy. So people blithely suggest that we can just reward a person that came in this country illegally 18 months ago, never had a job, but because they weren't caught and deported in the interim, they get to stay here legally forever and be on a guaranteed path to citizenship, whereas your friend has to go back home, the lady that wrote you. We cannot treat this lightly. So if we do this thing, and I'm prepared to work on it and try to do it in a good way, we absolutely have to do it in a way that doesn't damage too much the rule of law. It will damage the rule of law because it's a violation of the rule of law to reward somebody who came illegally, give them benefit of their act. Someone robs a bank and you catch them and they got the money, they have to give the money back. They don't get to keep the money. You don't get to keep the benefits of your activity normally. So we're willing to reconsider that. We're willing to, as a nation, compassionately, and I think the American people are willing to do this. But don't you feel, Senator Lee, that there's a strong sense that people are uneasy about it? They know this isn't they don't like having it, that this is a thing that they feel like they must do, but they know that it isn't a good thing. It should be avoided in the future.
The American people are a compassionate people. They're a people who welcome immigrants because we're a nation of immigrants. We always have been, and I think most of us hope that we always will be. We want people to continue to come to this country, and it's this sense of compassion that causes many of us to feel some sense of concern about this particular legislation. Because this legislation goes far beyond simply showing compassion. This legislation, in some ways, is the opposite of compassionate when you consider it from the perspective of those who, like this woman who wrote this letter to me, have come here legally. And those who, unlike her, have not yet gotten here but have waited in some cases for years outside the United States, spending a lot of money and a lot of time hoping and praying that one day they too will get to immigrate to this country legally. We do them a great disservice when we say that your effort, the time, the blood, sweat, and tears that you've devoted to this process is all for naught. Because all you had to do was come here illegally, and you would have been put not just on a pathway to legalization, but on a pathway to citizenship. This was one of the more enlightening moments of the Senate Judiciary Committee markup of this bill, was that when our friend and our colleague, the junior senator from Texas, introduced an amendment that would have done one simple thing to adjust that process, all hell broke loose. So Senator Cruz introduced an amendment that said would have left everything else about the bill intact, would have made everything else in the bill identical to what it says now, but with only one change, would have said that those people who enter into RPI status, enter into the pathway to legalization, would not ultimately become citizens. They could ultimately become lawful permanent residents or the functional equivalent thereof, but they would not become citizens under the bill. Everything else would be left intact. So they would be allowed still to come in out of the shadows. They would be allowed to stay here. They would be allowed to work here. And we could have a separate debate and discussion over whether or not that would be the right approach in and of itself. But this particular amendment focused simply on the citizenship aspect of it. And yet you would have thought, by the reaction to this, that this was offering up something horrible, something draconian because the proponents of this bill couldn't even handle that change that would have said, let's have there be some consequence at least for the fact that this group of people entered here illegally. Let's at least not right now put them on a pathway to citizenship so that they can vote and exercise all the other rights that accompany citizenship to this great country. So yeah, I do think this is strange. I do think that the American people, not in spite of the fact that they're compassionate, but because of the fact that they're compassionate, deserve more than to have the rule of law turned on its head, and deserve more than to have those who have taken the time and expended the energy and the financial resources to immigrate here illegally, have their sacrifice denigrated to the point that it means nothing or less than nothing.
That is a very interesting insight that you made. I believe Senator Schumer was particularly hostile to that amendment and said, without citizenship, there is no reform. In other words, we won't agree to anything. That's absolutely non-negotiable. But I thought about it a lot during 2007 and that bill, and have been thinking about it since. I believe after 1986, where we gave amnesty and citizenship with a promise of enforcement, and they didn't happen. We promised it wouldn't happen again. We wouldn't do another amnesty. This was a one-time amnesty that wouldn't happen again. That it should be the clear policy of the United States. If you enter the country illegally, you do not get every benefit, every single thing that America can provide and does provide to people who enter lawfully. And I don't believe we should and certainly are not required to provide citizenship to somebody who entered the country unlawfully. It's just not required. And to condition the whole bill on attacking Senator Cruz's amendment, I thought was odd and revealing, as you did. It was a surprise to me in the intensity of their pushback on that. But it's not. I don't believe it should happen, and I don't think it should. I don't think it's the right thing. So the person would be able to legalize, get legal permanent resident status, and be able to participate in America. Of course, their children would be citizens, but you don't get everything that if you come illegally. And I read a brilliant piece recently by a Yale graduate lawyer, Marine, and he talked about the military. So we act like somebody who comes into this country legally, it's just unthinkable that they would be required to move themselves back where they came from. And it's common word. We tell our military guys all the time to move your family. Go to West Texas. Go to Alabama. Go to Germany. Go to Japan. Go to Korea. Spend 18 months in Iraq with your life on the line. Leave your family. They do it all the time. So you come to this country under a lawful condition that you can come for so many months and you volunteer. You sign up. I come in, I get to stay so many years, and I'm supposed to go home. Is this somehow unkind? Is this immoral to expect those people, when their time is up, that they ask for to go home? Some of the thinking that came up in the committee seemed to be totally oblivious to this fundamental concept. You have certain requirements. You're not allowed to pay a guide and come across the border illegally and 18 months later demand a pathway to citizenship in the United States. It's just not law. It's just, I don't know what that is, but it's not law. It's not the way principled policies should be executed. But we're willing to consider and work through a process, and I've said for some time, people have been here a long time and they've done well, and we want to be compassionate. We can work through it. But we need to, when we come through this system, we need to have no doubt in the future, that somebody who overstays a visa, Somebody who comes in the country illegally, if apprehended, is going to be deported. And if we don't make that commitment intellectually and morally and legally, then we have really guaranteed we'll have another one, don't you think? Another amnesty fight and sadness, and the integrity of our immigration law will be further degraded.
As shortly as past is prologue, this will happen again if we do it in the wrong sequence. Sequencing matters. You know, when I was 6 or 7 years old, my mother pointed out to me that you don't try to butter the toast before you've toasted it. You toast it first, then you put the butter on. There are all kinds of examples we could come up with of where you need to follow the right sequence. And if you don't follow the proper sequence, you're not going to get the kinds of results you want. This is yet another area where this sequence matters. Now, I'm convinced that we can treat those 11 million people who are currently here illegally with the dignity, the respect, and the compassion that we want to treat them with as Americans. I'm convinced that we can find a way to do that, and I'm convinced that we can find a broad-based bipartisan solution to do precisely that. I'm less convinced that it makes any sense to do that now before we fix the underlying problem. Again, it's a matter of simple sequencing. We've got to first stop the flow of illegal immigration, and once we've stopped that flow, we'll be in a better position to ascertain the needs of those who are currently here illegally, because it's only in that circumstance that we'll know how best to address this. Now, along those lines, I'd like to address an issue that sometimes comes up with this. Sometimes arguments are made by the proponents of this bill that if you don't support this bill, not just if you don't support immigration reform generally, but if you don't support this particular bill, that you're somehow anti-immigrant, or that you're categorically an uncompassionate person, that your heart is made of stone, that your ribs are made of concrete, and that you have no heart. I think that's a reckless and irresponsible argument. I think that's an argument that is beneath the dignity of this august body. During the Judiciary Committee's markup of this legislation, one of our colleagues, I think it was the junior senator from Texas, introduced another amendment, an amendment that in some way would have limited the ability of those currently illegally in the country to participate in certain entitlement benefits, certain anti-poverty benefits that would otherwise be available to them. Perhaps it was the Earned Income Tax Credit. I don't remember the exact provision. But it would have had some broad application to make sure that those who are currently here illegally would not, during this RPI period, be able to benefit from federally funded entitlements. To my great dismay, one of our colleagues on that committee, who is an avowed supporter of this bill, personally attacked the junior senator from Texas simply for having introduced that amendment. And it wasn't enough for him to say, I disagree with this amendment, or I think this amendment is bad policy. The attack went something like this: you don't care about these people. You don't care about their children. You're willing to let their children remain hungry and uneducated. You don't care about them. You are not compassionate. With respect, I think that kind of comment has no place here. It's not helpful. It's not productive. And it's something that completely clouds the issue. It is because we are compassionate that we do need to ask these questions. Look, we're in a difficult spot as a country. We're trying to do everything we can to make solvent those programs that are designed specifically to alleviate some of the needs of the most vulnerable in our society. And unless we make sure that we're in a position economically to be able to sustain those programs, we're going to run out of money. And when we run out of money, it will be the poor, it will be the vulnerable who suffer most as a result of our inability to pay for those programs. So with respect, I would advise all of my colleagues, particularly those who have made comments like that one, to resist the temptation that some of them have succumbed to in recent weeks, to say that anyone who opposes this bill is somehow uncompassionate. It is because we are compassionate that we have to ask difficult questions. It is because we are compassionate that we have to propose amendments that we think are necessary in order to make the programs upon which society's most vulnerable have come to depend more sustainable.
Senator Lee, I think I'm glad you mentioned that, because we have to have an honest debate. We have to have an honest discussion about what is in the national interest of the United States and how immigration fits into that. And first and foremost, do we want to have a lawful system or not? Do we want to allow lawlessness to continue in the future? And that's not unkind to talk about that. Prime Minister Cameron of the UK in London recently made this remark. They're wrestling with immigration and how to do it the right way in the United Kingdom. He says, quote, "There are those who say you can't have a sensible debate because it's somehow wrong to express concerns about immigration. Now, I think that's nonsense," close quote. I think we can have a sensible discussion about it, and we ask about how many people come, what skills they should possess, what America would be benefit from most in the immigrants that we have come to our country, what immigrants will be most likely to be successful and flourish and do well. We know statistics establish that people who come with about 2 years of college and speak English, almost all do very well. But people come without high school diplomas, they don't do as well. So if you can't accept everybody, we ought to think about trying to develop a system that allows the people who can be the most successful and take advantage of America would be helpful. Prime Minister Cameron goes on to say, "While I've always believed in the benefits of immigration, I've also always believed that immigration has to be properly controlled. Without proper controls, community confidence is sapped, resources are stretched, and the benefits that immigration can bring are lost or forgotten," close quote. So I think that's somewhat in line with the points you were making. I see the chairman of the Judiciary Committee, Senator Leahy, who has wrestled with these issues longer than I have, and conducted a hearing that allowed a large number of amendments, and although unfortunately some of the members, even if they liked our amendments, wouldn't agree to vote for them, but we had a process that allowed some airing of the details of the bill, and a lot of amendments were offered. Senator Lee, thank you for participating in this discussion. Thank you for coming to the Senate with fresh ideas and enthusiasm and passion for America, for the rule of law, for the proper functioning of our branches of government, and the classical constitutional heritage of this nation. I'm honored to serve with you.
Thank you.
Would you yield the floor?
President.
Senator from Vermont.
Mr. President, I was here earlier, and this had been the distinguished presiding officer, and now we have another distinguished presiding officer. And Madam President, it is good to see you here as a member of the Senate Judiciary Committee. And as the presiding officer knows, the Senate Judiciary Committee held lengthy and extensive public markup sessions to consider the Border Security and Economic Opportunity and Immigration Modernization Act, S-744. We worked late into the evenings. We also started pretty early in the morning. We debated the bill. We considered hundreds of amendments. But the public saw our consideration firsthand. We streamed everything we did on the Internet, and it was broadcast on television. Took all the proposed amendments, Republican and Democratic alike. We put them on our website. We updated the committee's website to include adopted amendments in real time. I heard from people all over the country that they felt they actually had involvement in what we were doing, which is what I wanted. And I appreciate the fact that both Republicans and Democrats, members from both sides of the aisle, praised the transparent process, also praised the significant improvements to the bill that were made by the Judiciary Committee. In fact, the markup process followed 3 additional hearings on top of all the others we'd had, with 26 witnesses. And the bill as amended was supported by a bipartisan 2/3 majority of the committee. And I sent that bill, S-744, to the Senate on behalf of the Judiciary Committee. I'm filing an extensive committee report as well. And I hope that the report is going to be a valuable resource for senators. It explains not only the underlying provisions in the legislation and its history, it also summarizes all the amendments that were adopted and also those that were rejected. So, in order for all senators to be able to file amendments and work on this bill, of course, the Senate first needs to proceed to the bill. I had hoped that what had become all too typical obstruction would not infect these proceedings. Senators from both sides of the aisle worked together to develop this legislation. Senators from both sides of the aisle had amendments adopted by the Judiciary Committee. Almost none of the more than 135 amendments adopted by the Judiciary Committee were adopted in party line votes, unlike this week's vote in the House, in which nearly every member of the Republican conference stood together to prevent dreamers from being able to stay in our country. The one thing that ought to unite all of us are the aspects of the DREAM Act. These young people are here through no fault of their own. They've enriched our nation. They've enriched this debate. I'm proud that we in the Senate are considering inclusive legislation that supports them. And I hope a fair process in the Senate finally prompts action in the other chamber. I don't know how anybody who professes to care about family values, who professes to care about other people, can sit down with these young people, the dreamers, and not be moved, and not want them to have the same advantages that our children, our grandchildren have. The dysfunction in our current immigration system affects all of us. It's long past time for reform. As members of the Senate Judiciary Committee from both parties said at the conclusion of our proceedings, this is a matter of great significance to the American people. And the Senate should debate it, but the Senate's being delayed from doing so by a small minority of opponents. This is not a time to have a tiny handful stop a debate. Madam President, we senators, there's only 100 of us, 99 now with the loss of our dear friend Frank Lautenberg. But you take a Senate of 100 people, we represent over 300 million Americans. They're counting on us not to use stalling tactics, but to stand up. Vote for or vote against, but stand up. When you stall and refuse to let votes come in, it's an easy way to say I'm voting maybe. Then you can go back home and you can be on everybody's side. Whether people are for it or people are against it, I'm on your side, because nobody can point that you voted one way or the other. That's not what we're elected for. We're elected to stand up, take a position, yes or no, not maybe. Legislation we seek to bring before the Senate was a result of senators from both sides of the aisle who came together and made an agreement. What was initially a proposal for the so-called Gang of Eight became, through the committee process, the product of a group of 18. Now let's have a product of a group of 100, representing all states in this country. Amendments authored by 17 of those 18 members were adopted into the bill. 17 of the 18 members of the Senate Judiciary Committee had amendments adopted in the bill. A bipartisan majority, more than two-thirds of the Senate Judiciary Committee voted for the bill the Senate is being called upon to consider. Now, I'm honored to serve as both the chairman of the Senate Judiciary Committee and the President pro tempore of the United States Senate. That's an office established in Article 1, Section 3 of the Constitution of the United States. I've been privileged to serve the people of Vermont for more than 45 years, the last 38 as their senator. But one thing I've learned many years ago was taught to me by distinguished majority leader at that time when I came here, Senator Mike Mansfield. It's how important it is for senators to keep their commitments, keep their word, to stay true to their agreements. The senators who come together to help develop this bill do those things, I have no doubt we'll be able to end this filibuster and stop voting maybe, but actually vote up or down and pass this fair but tough legislation on comprehensive immigration reform. Out there, our history, our values, our decency conspire us finally to take action without the prolonged partisanship that often paralyzes this chamber. We need an immigration system that lives up to American values. This is a time we're called upon to come together. Few topics are more fundamental to who we are as a nation than immigration. The Statue of Liberty has long proclaimed America's welcome. Give us your tired, your poor, your huddled masses yearning to breathe free. Send these, the homeless, tempest-tossed, to me. That's what America stood for. That's what we should continue to represent. That's the America that attracted my maternal grandparents from Italy to Vermont. My paternal great-grandparents from Ireland to Vermont. Immigration throughout our history has been an ongoing source of renewal of our spirit, our creativity, our economic strength. Our bipartisan legislation establishes a path to earn citizenship for the 11 million undocumented immigrants in this country. It addresses the lengthy backlogs in our current immigration system. Backlogs that kept families apart sometimes for decades. It grants a faster track to the dreamers brought to this country as children through no fault of their own, and to agricultural workers who provide our nation's critical food supply. It makes important changes to the visas used by dairy farmers and the tourists and by immigrant investors who are creating jobs in our communities. It addresses the needs of law enforcement, requiring the help of immigrants who witness crime, who are victims of domestic violence and human trafficking. It improves the treatment of refugees and asylum seekers so that the United States will remain the beacon of hope in the world. And it's going to make us all safer. This is a measure the Senate should come together to consider and pass. We should do what is right, what's fair, what's just. Immigration reform is an important economic issue, a civil rights issue, and a fairness issue. If a majority of us stand together, we stay true to our values and our agreements, I believe we can pass legislation to write the next great chapter in the American history of immigration. Those of us serving in the Senate who are immigrants understand that. Those of us who are children or grandchildren of immigrants understand it. Just as my wife's family came to this country and created a better state of Vermont. They understood it, but so many can't. I know I give a speech that the distinguished presiding officer knows better than anybody in here. She knows what it is to come to the country and become part of this great country. and can come as an immigrant and then become a United States Senator. And as President pro tempore, I'm delighted to see the acting President pro tempore in the chair. And I will suggest the absence of quorum and ask that the consent the time be divided equally.
Without objection. And the clerk will call the roll.
Mr. Alexander.